Bryan Kohberger is behind bars for life, but he's hoping to change that. Does he have a shot?
Boy, does he have an uphill climb. It would be like me trying to climb Mount Everest the first time without ropes and oxygen.
And guess what? Kohberger has people rallying behind him, and they're sending him cash. I'll tell you the name of his biggest benefactor. I'm Jeanette Levy, and this is Crime Fix.
A commissary ledger from Idaho's maximum security unit lists 6 deposits made within the first 7 days in inmate-occupied cell block J. The inmate is Bryan Kohberger. The largest deposit, $300, came from a woman his own phone once saved under a single word, mother. Picture that ledger sitting next to the sentencing transcript where a judge read the names of 4 murdered students into the record, one document tracking grief, the other tracking grocery money. That's the entire story of this video in 2 pieces of paper. Before we go deeper into what the records actually show, make sure you're subscribed to the Crime Infinity, because we don't just cover the story, we follow the evidence. Bryan Kohberger is serving 4 consecutive life sentences plus 10 years for burglary at Idaho's maximum security institution, inmate number 163214. He arrived there the same day he was sentenced, and according to his own attorneys, he stood in open court, raised his right hand, and admitted under oath to killing 4 University of Idaho students. That should have been the end of the paperwork. It wasn't. More than a year later, Kohberger filed a petition for post-conviction relief, claiming he was coerced into that confession, that his own legal team allegedly misrepresented what a life sentence would look like, allegedly described death row conditions in vivid, frightening detail, and allegedly withheld exculpatory material, including a disputed claim about unidentified hair recovered from one victim's hand. He is, in writing, now saying the plea he swore to under oath was not the plea he actually wanted to make.
Bryan Kohberger is serving 4 life sentences, and you might think after standing up in open court and raising his right hand and swearing to tell the truth and admitting that he murdered 4 University of Idaho students that he would go to prison and you'd never hear from him again. That was the hope of the families of Maddie Mogan, Kaylee Gonsalves, Ethan Chapin, and Xana Kernodle. But that's not what's happening. Bryan Kohberger has made it clear that he's not going away, at least not quietly. Many people across the country believe that Bryan Kohberger is guilty. He said that he was guilty. But now Kohberger, more than a year after he was sentenced to 4 life terms plus 10 years for burglary, has filed a petition for post-conviction relief with the Ada County courts. Kohberger says he was coerced into confessing and false promises were made to him by his legal team. He claims he wasn't told about exculpatory evidence. A claim has come to light that Ethan Chapin had unknown hairs in his hand, but whether that material was actually hair is in dispute. Kohberger says that his lawyers told him he would most certainly get the death penalty and that the conditions on death row were poor. Kohberger wrote, "A gross misrepresentation of and promises regarding what a life sentence would immediately afford petitioner and a gross misrepresentation of death row in Idaho, including an elaborate story of counsel's horrific experience touring an actual 8x8 death row cell, all communicated to petitioner and his family, allegedly by IDOC through counsel, thus constituting threats and promises made to induce a plea agreement." Bryan Kohberger arrived.
Here's the visual worth holding onto for the rest of this video. A man who publicly confessed to killing 4 people is now filing paperwork from a cell, funded by outside deposits, arguing that the truth he told a judge under oath wasn't really the truth at all. A confession bought with someone else's money, trying to buy its way back out of a courtroom.
Arrived at Idaho's maximum security institution on the same day he was sentenced, July 23rd, 2025. He's been there ever since. He's inmate number 163214. He spends his days 23 hours a day in his cell alone. He's filed grievances claiming fellow inmates are harassing him. And since he arrived, he's had a number of people sending him money. His biggest contributor, his mother, Maryanne Kohberger. Kohberger has asked to proceed with his post-conviction petition on a partial payment plan. He attached his financial records from prison to the petition. Those records show 6 people deposited money into his Keefe Commissary account within a week of him arriving at prison. Kohberger's mother made the largest deposit, $300. In fact, Kohberger's mom has deposited money consistently. During his first month in prison, she deposited $700 into his account. Since his incarceration, Bryan Kohberger's mother has deposited more than $9,200 into his commissary account. Now,
The financial records attached to his own petition tell a story his legal filing never intended to tell. 6 people deposited money into his prison account within a week of his arrival. His mother, Maryanne Kohberger, made the largest single deposit at $300, and in his first month alone, she put in $700. Since his incarceration began, records show she has deposited more than $9,200 into her son's commissary account. Total deposits across all contributors, $10,812. Total spent, $10,635 and change.
is that a lot of money? It sure sounds like it to me, but we'll get to more on that shortly. The rest of the deposits came from his supporters. The total deposited into Bryan Kohberger's account over the last year, $10,812. The expenses totaled $10,635.10. His balance earlier this month was $177.03. Now, that may not include the 20% the state takes for restitution for the victims. So what can Kohberger buy? The prison website states residents housed in Idaho Department of Correction prisons and community work centers may purchase supplemental hygiene products, food, electronics, and clothing through the prison commissary. Commissary goods are provided through a contract with Keefe Commissary Network. Each facility has the ability to customize their commissary menu to meet the needs of their custody level. Residents may order products weekly using their accounts. Orders are delivered weekly in each facility. So you might be asking yourself, what does Keefe Commissary offer? Which products? The Keefe Group's website shows it offers a number of products, including skin and hair care products, vitamins, deodorants, toothpaste, and supplements. There are clothing options too, such as jeans, shirts, shorts, sweats, underwear, shoes, and boots. And then televisions, typewriters, CD players, portable radios, headphones, and fans. Snacks are also available.
His balance earlier this month, $177.30, and that figure doesn't yet account for the 20 to 25% Idaho typically withholds from inmate accounts for victim restitution. Compare that number to what a former federal prison warden would tell you is normal.
So to dig into these records about Bryan Kohberger's prison finances, I want to bring in Dr. Dwayne Hendricks. He is a former federal prison warden, so he can look at this stuff with me and really break it down for us. Dr. Hendricks, thanks so much for coming on.
Thanks for having me, Angela. It'll always be good to be with you.
Yeah, you too. Let's talk a little bit about this. I was shocked when I saw the number, the amount of money that has been deposited into Bryan Kohberger's commissary account since his incarceration. It's over $10,000 now, and that's the first year. And then he's spent most of it. I mean, he's only got $177 left, according to the records we're seeing. Is that amount of money, over $10,000, is that a lot of money to be deposited into one of these accounts within 1 year?
Yes and no. And again, it depends on the inmate, their financial situation prior to their incarceration, and also the family and friends and those supporters who are behind the individual that is behind the fence. So I can tell you the average in the federal system, the average amount of money the inmates may have would be less than $500 at any given time. And that would even include the amount of money that they would make working at the facility. And most inmates probably make, 30, 40 cents an hour, depending on the type of work that they're doing. So the $10,000 deposit for this particular inmate is pretty high because typically, like I said, most inmates, carry.
In the federal system, the average inmate carries less than $500 in their account at any given time because most inmates earn 30 or 40 cents an hour on facility jobs, and because every dollar sitting in that account is a dollar the state can claim toward fines and restitution. $10,000 in a single year isn't just above average. It's a figure most working adults wouldn't hand a family member without asking hard questions, and it's a figure this family sent to a maximum security cell without. as far as the public record shows, asking any at all. So what does that money actually buy inside those walls? According to the prison's own commissary structure, residents can purchase hygiene products, snacks, clothing, and electronics through a contracted vendor. Everything from seafood and meat snacks to televisions, typewriters, and portable radios. Kohberger has reportedly followed a vegan diet since his arrest, which narrows what that money likely goes toward. But even a limited menu adds up fast at commissary prices. What it doesn't explain is the scale. This isn't a mother sending pocket change for soap and stamps. This is a sustained, deliberate financial pipeline into a facility housing a man who has already confessed, in open court, to murder. And that raises the question this case keeps circling back to. Why does a system built to hold a confessed killer accountable also leave a door open for his family to fund his comfort while he tries to undo that confession? That's not a rhetorical flourish. It's the actual mechanical gap in how post-conviction relief works. The state prosecutes the crime. It does not regulate who pays for the appeal. Because that's what this filing really is, an appeal in slow motion, wrapped in the language of coercion.
Yeah, it's been a long time. So let's talk a little bit about Bryan Kohberger's petition for post-conviction relief. This is a guy who went into court and said he voluntarily and intelligently, waived his right to a trial. He was agreeing to this. He did it. What are your thoughts on him now filing this motion?
Boy, does he have an uphill climb. It would be like me trying to climb Mount Everest the first time without ropes and oxygen. It's really going to be very difficult for him. And the reason why is before the judge accepted his plea, the judge went through what we call a plea colloquy. And that's where the judge asks a lot of questions to determine the voluntariness, intelligence of the plea. And basically, it's a way for the judge to bulletproof, if you will, the plea so that it is not going to be vulnerable to an argument later on that it was involuntary. So not only did the judge, first of all, put Mr. Kohberger under oath to answer these questions, but the judge went through a whole lot of questions like, are you satisfied with your lawyer? Are you satisfied with how they've advised you? The answers to those questions were yes. Has anybody forced you to plead guilty? The answer to that was no. Has anybody promised you anything other than what is in the plea agreement offered by the government? The answer was no. So the judge, in a very careful way, sort of took out the avenues for escape later on that from the plea agreement that Mr. Kohberger might want to try, like saying his lawyer was ineffective. He was unhappy with what his lawyer advised him, or that he's been made promises by the lawyer that now he's saying are not kept. So those sorts of questions are going to make it really, really hard for Mr. Kohberger to get his plea withdrawn.
Legal analysts reviewing the case have pointed to one document that makes Kohberger's claim exceptionally difficult to sustain, the plea colloquy. Before any judge accepts a guilty plea in a case this severe, the judge is required to walk the defendant through a series of sworn questions specifically designed to prove the plea was voluntary and informed. Are you satisfied with your attorney's advice? Kohberger answered yes. Has anyone forced you to plead guilty? He answered no. Has anyone promised you anything outside the written agreement? Again, no. Every one of those sworn answers now stands directly in the path of his current claim, because a court doesn't have to take his word for what happened behind closed doors with his legal team. It has his own recorded testimony, under oath, saying the opposite. That's the moral refrain worth sitting with here, because it's going to repeat. A confession isn't erased just because the person who gave it changes his mind later. Kohberger swore, under oath, that no one forced him. He swore, under oath, that he was satisfied with his lawyers. That sworn record doesn't disappear because a new filing says otherwise.
He said that his attorneys, who he said were fantastic and great, I'm paraphrasing, with the colloquy, he basically said he was happy with the representation, all of everything you just went over. But he said that they basically coerced him, that he, they said, we went to death row. It's horrible. The firing squad's waiting for you. This is going to be a legal victory. Does he have anything, to hang his hat on there? Because he's basically saying he was coerced into lying, into falsely confessing. And so he's saying his attorneys were basically like, you're going to get the firing squad. You need to take this deal.
Well, first of all, I don't know what the lawyers are going to say in terms of how they phrased their advice, but lawyers do play a counseling role too. And part of that role is to advise the client of the potential consequences of the plea. And, certainly had Mr. Kohberger gone to trial and been convicted, it's very likely he was going to get the death penalty. It was capital charges. Uh, and in a high profile case like that, I would have been shocked had he not gotten the death penalty, had he been convicted after trial. And so I think it's appropriate for the lawyers. Again, I don't know what they said or how they phrased it, but to let him know what he's facing if he doesn't plead guilty. Now that doesn't make a plea involuntary. It's short of browbeating someone, you're just not going to get to a place where the court is going to say that's an involuntary plea, particularly when the judge asked, has anybody forced you to do this? And the answer was no.
Attorneys familiar with post-conviction litigation have noted something else worth understanding plainly. Lawyers advising a client facing capital charges are legally required to explain the realistic consequences of going to trial, including the very real possibility of a death sentence in a case this high profile. Explaining consequences honestly, even starkly, is not the same as coercion. Courts have consistently drawn that line, and it's a line Kohberger's petition will have to cross convincingly, using more than his own account of private conversations with his legal team. There's also the practical incentive worth naming, because it isn't speculation, it's how the corrections system actually works. Petitions like this aren't only about reversing a plea. Sometimes they're a mechanism for something smaller and more immediate, a transfer. A confessed killer housed in Idaho's maximum security unit, 23 hours a day in isolation, far from family in Pennsylvania, has a documented incentive to generate procedural findings, mistakes, mishandled requests, anything that could support a future habeas petition arguing for relocation to a lower security facility or a facility closer to home. That doesn't mean this petition is fabricated. It means the system he's now navigating rewards persistence, regardless of whether the underlying claim succeeds.
Dr. Hendricks, how common is this for somebody charged with, a horrific crime who's pleaded guilty? He said he did it. Now he's saying he was coerced and made false promises and lied to. How common is this for then an inmate to come out of the woodwork and say, I want to take back my plea. I want to withdraw this. And now I want a trial. Is this common in your experience?
Very common. And I know he's not housed case or, the process of going through the judicial system. So I'm almost certain that even when he did this plea, he already had it in the back of his mind that at some point that he was going to try to file a petition. I can tell you, as someone who retired from federal service 3 years ago, I'm still dealing with different habeas petitions and issues from inmates from all various types of issues, whether it's related to their time, whether it's related to their pay while they were working, whether it was related to, COVID issues, how we were operating our facilities during that time. So this is very common. And I'm sure the legal staff at the institution is fully aware of what he's trying to do, especially when he wants access to the law library or his legal materials. They just need to follow their processes and their procedures, because ultimately this is, to me, is going to be more than just him getting a new trial, and pulling back. I also believe that he's trying to see if the staff there can make any mistakes so he can file habeas petitions against them in relation to this process, so he can ultimately be removed from that maximum security facility and or be placed in a prison outside of the state of Idaho so he can be closer to his family and friends in the state of Pennsylvania. So I think he has a bigger play here in terms of what his plans are.
It's so interesting you brought up the possibility of a habeas petition, because I've been saying that from the beginning, that I thought he would be filing a habeas petition at some point in time, and that this is not the last we had heard of him when he pleaded guilty. So is this all possibly laying the groundwork for that habeas petition? Because that's a different type of petition than just post-conviction relief.
Yes, he is looking for some sort of loophole to get his way out of that facility, either to a lesser security place there in Idaho, or possibly become a state border somewhere closer to his family. And again, we call them malingerers. He sounds like an inmate who malingers and constant fouling and constant having to make sure that the staff are doing their job, because ultimately, if he can find any issues with what they're doing, he's going to find a way to try to get himself out of that facility. And like I said, again, to get closer to his family. And ultimately, he's looking for his freedom. But I think right now, he's more or less trying to lay the groundwork so that way he can get out of that J unit, the maximum security facility there in Idaho.
And once again, the same fact sits underneath all of it. A confession isn't erased just because the person who gave it changes his mind later. Kohberger's plea agreement waived his right to appeal, a waiver he accepted, on the record, in exchange for avoiding a trial that would have forced the victims' families to relive every detail in open court. If the state chooses to fight this petition, and most legal observers expect it will, that waiver becomes the first wall his filing has to climb.
To anybody who's watched this case closely, I mean, I'm not shocked by him doing this. I had a very good feeling he was going to do something like this. Does this put his plea agreement in jeopardy? Because as a part of that plea agreement, he waived all appeals. So could the state come back and say, you know what, buddy, you want a trial? Let's do it, because you just violated the terms of the agreement.
I doubt very seriously that the state would do that. Now, again, I'm not the state of Idaho, but I think part of the rationale for the plea in the first place, and I realize that there was some dissent within the victims' families about this, but part of the reason for doing this is it spares at least some of the families the ordeal of a trial, to have to relive this. And so I think what we're going to see, and again, I could be wrong, but I think what we're going to see is the state say, no, Mr. Kohberger, you're wrong. This plea is not involuntary, and they're going to fight this plea withdrawal motion. That's what I would expect, but anything can happen. So I'll wait with you and watch.
Yes.
Not impossible to challenge, but according to attorneys who've handled cases like this, an uphill climb, without ropes, without oxygen, and without much room for error. What almost never gets asked out loud in coverage of cases like this is the simplest one. Who is actually paying for the appeal, and does the public have any right to know?
I've covered cases where you worked to get people out of prison who were convicted and said they were wrongfully convicted and they were actually factually innocent. Have you ever had a case where a defendant entered into a plea agreement because they were so afraid that they were going to get the death penalty, because the temperature was so high surrounding the case, and emotions were high, and there was fear, there was never going to be a fair trial? Have you ever had a case where a defendant pleaded guilty to avoid that and then won a post-conviction relief motion?
Yes, I actually had one in our old stomping grounds of Butler County, Ohio. And it wasn't a high profile case in terms of national high profile, but within Butler County, it was high profile. And our client was led to believe that she was going to get the death penalty. The lawyer did a horrible job advising her. And then years later, we filed a motion to withdraw her guilty plea after trial, which is much harder, by the way, than asking to withdraw your plea before sentencing. We had filed it. I'm sorry, I said but after trial. We moved to withdraw her guilty plea after her sentencing, based on ineffective assistance of counsel, because she was misled about the death penalty, which could have been sought, but it wasn't. And she was able to get some relief because of ineffective assistance of counsel. So it's not that it's impossible, it's just hard. And that was a hard fight in that case. And we were not dealing with the same magnitude of the charges that Mr. Kohberger faced.
Idaho's Department of Correction does monitor inmate account deposits, in part to flag exactly the kind of activity that might indicate coercion, debt collection, or improper influence among inmates. Whether that same scrutiny extends to a confessed murderer's mother sending thousands of dollars while he attempts to withdraw a sworn guilty plea is a separate question, and it's one the public record, as filed, does not yet answer. A confession isn't erased just because the person who gave it changes his mind later. That's the phrase this case keeps returning to, and it's the standard against which every future filing in this petition should be measured. If you want to follow this case past this video, pull Bryan Kohberger's post-conviction relief petition directly from the Ada County Court docket. It's public record, and it lays out, in his own words, every claim discussed here. Read the plea colloquy transcript alongside it, and then answer this in the comments. Should courts require public disclosure of who is financially backing a post-conviction appeal in a capital murder case? Or does that cross a line into punishing a defendant's family for standing by him? If this kind of case file breakdown is what you come here for, hit like, share it with someone who'd rather have the documents than the headline, subscribe to the Crime Infinity, and turn on notifications, because the moment new filings drop in this case, we'll be back with exactly what they say.